Welcome back to the Constitutional Clarion. This video is a quick update upon two videos that I did some time ago about the validity of Section 18C of the Racial Discrimination Act 1975, which is a provision which makes certain race-based speech and actions unlawful. I will provide links to those videos in the comments section below so you can see the full arguments that I laid out there. The videos were made in the context of litigation that had been brought by Senator Mehreen Faruqi against Senator Pauline Hanson concerning a tweet by Senator Hanson to the effect that Senator Faruqi should go back to Pakistan, albeit in rather less polite terms. Senator Faruqi contended that this was unlawful under Section 18C of the Racial Discrimination Act. Senator Hanson denied that it was unlawful and also challenged the constitutional validity of Section 18C on the ground that it breached the implied freedom of political communication. The Federal Court handed down its judgment on the case at first instance this morning. Justice Stewart held that the tweet by Senator Hanson was unlawful and that Section 18C did not breach the implied freedom of political communication. Senator Hanson was ordered to delete the relevant tweet and pay Senator Faruqi's costs, although the parties were granted liberty to apply for a variation of the order about costs. The judge also rejected Senator Faruqi's request that he make an order that Senator Hanson undertake anti-racism training at her own expense. Justice Stewart noted that the terms of such training were unclear and that, quote, "It is not at all clear that Senator Hanson would benefit from such training," unquote, and that, quote, "futility is a relevant factor to be taken into account," unquote, in relation to the grant of relief. Senator Hanson has stated that she will appeal the decision. In this video, I will explain the part of the judgment that deals with the constitutional issue. I will not address the substance of whether the tweet actually breached Section 18C or anything concerning the politics of the issue. I'm going to leave the politics to the politicians. So this is simply about the constitutional issues in the case. Now, just to recap, Section 18C is as follows. It says, "It is unlawful for a person to do an act otherwise than in private if A, the act is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate another person or group of people, and B, the act is done because of the race, colour, or national or ethnic origin of the other person or some or all of the people in the group." Now, that needs to be read in the context of the following section, Section 18D, which provides exceptions. So it says, Section 18C does not render unlawful anything said or done reasonably and in good faith in the course of any statement, publication, discussion or debate made or held for any genuine academic, artistic or scientific purpose or any other genuine purpose in the public interest. The question in the case was whether Section 18C, as read with Section 18D, breaches the implied freedom of political communication that the High Court has identified in the Constitution. The High Court has set out a three-part test to consider when deciding such a question. Part 1 of the test asks, does the law effectively burden the implied freedom of political communication in its terms, operation, or effect? In this case, Section 18C makes certain kinds of communication, including political communications, unlawful. Senator Hanson and the Commonwealth Attorney General, who intervened in the litigation, accepted that the implied freedom was effectively burdened by the law. Senator Faruqi, however, disagreed, arguing that the purpose of the implied freedom is to allow people to make a free and informed vote, and that being exposed to racially offensive public acts that are committed unreasonably or in bad faith does not facilitate making such an electoral choice. There's an interesting discussion in the judgment about the vexed issue of the extent to which the implied freedom protects offensive communications. In particular, Senator Faruqi had argued that making racially offensive speech unlawful actually promotes the free flow of political discourse because it frees groups to participate in it who would otherwise be intimidated or excluded by such communications. Justice Stewart accepted that a law can both burden the implied freedom and ultimately serve to enhance it. For example, laws restricting political donations from those who would otherwise completely dominate the debate can have the effect of expanding that discourse by allowing other voices to be heard. This has previously been recognised by the High Court in the McCloy case about property developer donations. But in this case, Justice Stewart said that this issue is relevant at the third stage of the test concerning justification. He accepted that Section 18C does effectively burden the implied freedom. Part 2 of the test asks whether the purpose of the law is legitimate in the sense that it's compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. There were different views amongst the parties and intervener as to the purpose of the law. Senator Faruqi saw the purpose of Section 18C as supporting the legitimate claims of people to live with dignity, free from unwanted offensive communications, and to promote equality of opportunity in public life. Senator Hanson saw the purpose of the law as preventing racially offensive conduct. The Attorney General argued that its purpose was to, quote, deter and eliminate and thus protect members of the public from racial hatred and discrimination. If you go back to my earlier video, I had assumed that the purpose would be identified as protecting the dignity of groups of people so that they do not have to live with the stress, pressure and fear of facing racial abuse. The protection of human dignity was accepted as a legitimate purpose by the High Court in the Club case concerning safe access zones around abortion clinics. And it's also consistent with statements that were made by Justices Dean and Toohey in the original Australian Capital Television case back in 1992. Justice Stewart, however, favoured the Attorney General's view about the purpose being to deter and eliminate racial hatred and discrimination. I find this rather odd because I cannot see how making it unlawful to make racially offensive statements actually eliminates racial hatred or discrimination. While it might suppress some open expression of it, it's highly unlikely to convert anyone who actually holds such views. On the contrary, it's likely to create a sense of grievance and reinforce those views. It's also likely to drive those views underground or cause them to be expressed in anonymous forums. That's one of the reasons why I've decided to turn off the comments on this particular video, as I am confident that Section 18C would not at all deter many racially offensive comments being made there. If deterring and eliminating racial hatred and discrimination is really the purpose of the legislation, it makes it hard to see how it is fit to achieve that purpose. This is relevant to the third part of the test. It asks whether the law is reasonably appropriate and adapted to advance that legitimate object in a manner that is compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. In assessing this, the court now considers whether the law is justified as being A, suitable, B, necessary, and C, adequate in its balance. Now, this is all explained in more detail in my previous video on that issue. Here, Justice Stewart returned to the argument about whether limiting some forms of speech may ultimately enhance the speech of others. He noted the evidence that racially offensive speech can, quote, have the effect of silencing people and limiting their ability to participate freely in political communication, unquote. When considering the adequacy of the balance of, on the one hand, the degree of the burden of the implied freedom of political communication, and on the other hand, the importance of achieving the legitimate purpose, Justice Stewart took the view that Section 18C only imposed a very slight burden on political communication. This was because of all those exceptions in Section 18D in relation to what is said reasonably and in good faith for genuine purposes in the public interest. He did not seem to accept that this provision, despite those exceptions, has a chilling effect, given the uncertainty about whether any particular conduct would be regarded by a court as being done reasonably and in good faith or for a genuine purpose in the public interest. The lines drawn in making those assessments will not always be clear, meaning that anyone who wants to steer clear of litigation is likely to self-censor, affecting a wider range of political communications. All up, these are really difficult assessments to make, and minds may reasonably differ upon where to draw the line. It will be interesting to see if Senator Hanson proceeds with her appeal, how the appeal courts will deal with these issues and where they draw the lines. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.